All is well.
Good morning, Judge.
Good morning.
Whenever you're ready, we're gonna start in courtroom 2 with position 12, Mr. House.
Okay. All right, so is this your case, Ms. Duncan?
Yes, Judge.
This is Mr. Finland's case also. Good morning, both of you.
Good morning, Judge. Yes, this is my case as well.
Okay. Good morning, Mr. House. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Judge.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Absolutely.
Okay, you can put your hand down. Thank you, Mr. House. Ms. Duncan?
Yes, Your Honor. From my understanding, this is a negotiated plea. The state's recommendation in this case for the first charge of giving false name, address, or birthday to a law enforcement officer, the state is recommending 12 months to serve, 30 days, credit for time served, 15 days with the balance suspended. For the second charge of loitering and prowling, the state is recommending 12 months to serve, 30 days, credit for time served, 15 days with the balance suspended, and a stay away from 3665 Martin Luther King Drive Southwest.
Is that your understanding, Mr. Finley?
Yes, Judge Morrow, that is our understanding of the state's recommendation, of which we do agree, and additionally stipulate that the factual basis venue and ID.
Mr. Howes, it's my understanding that you wish to plead guilty to giving false information to law enforcement and loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Absolutely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
Mr. House, I'll accept your guilty plea as negotiated. Good luck to you, sir.
Assalamu alaikum.
Have a good day.
Next, we have position 7, Mr. Favors.
Good morning, Mr. Favors. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, now put your hand down. Thank you, Mr. Favors. Ms. Duncan?
Yes, Your Honor. From my understanding as well, this is a negotiated plea. And the state is recommending for the first charge of criminal trespass, 12 months to serve, 30 days, credit for time served, 15 days with the balance suspended, and a stay away from the Rolling Bend Apartments located at 2500 Center Street. And for the second charge of obstruction, the state is recommending 12 months to serve, 30 days, credit for time served, 15 days with the balance probated, and 40 hours of community service.
And Your Honor, that is, excuse me, sorry. That is my understanding of the state's recommendation, of which we do agree. I would just ask the court judge that once he does complete that 40 hours community service, if the balance of probation could either be terminated or be non-reporting.
What was the obstruction, Ms. Duncan?
You said, what was it, Your Honor? 1 second.
Yes.
Go to my other page. It is running slowly. My apologies. The obstruction was slow today. He was, they were pulling him over for a traffic stop, Your Honor, and he initially did not stop, but got out and ran away from officers once he pulled into a driveway.
All right. Thank you. Anything further, Mr. Finley?
Nothing further, Judge.
Mr. Favors, it's my understanding that you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Favors. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you finish the 40 hours of community service, the probation is going to terminate, okay?
All right.
All right, so the quicker you do that, the quicker you do the 40 hours, the quicker you won't be on probation.
Okay, sir.
All right, good luck to you, Mr. Favors.
All right.
Next, we have position 27, Varner.
Good morning, Ms. Helen.
Good morning, Judge.
Good morning, Mr. Varner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Varner? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Good morning, Ms. Webb.
Good morning, Your Honor. For Mr. Varner will receive a time served plea. The state is recommending 12 months to serve, 165 days, credit for time served, 165 days with the balance suspended, Your Honor. Nothing further.
Yes, Your Honor, that is our understanding of the recommendation. We accept the recommendation. We stipulate to the factual basis, venue, and ID.
Mr. Varner, it's my understanding that you wish to plead guilty to obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Varner. Good luck to you.
Boykins, position 2, Mr. Boykins.
And Your Honor, I put in the chat, I need to speak with, what is this? Oh, this is Mr. Boykins. I apologize. Just
Good morning, Mr. Boykins. I'm Judge Eric Morrow. This is the state court's all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Boykins?
Sir.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you. Ms. Duncan?
Yes, Your Honor, to my understanding as well, this is a negotiated plea. The state is recommending for Mr. Boykins, 12 months to serve, 28 days, credit for time served, 14 days with the balance suspended on the first charge, and a stay away from Family Dollar located at 2461 Riverdale Road in College Park. For the second charge of theft by shoplifting, the state is recommending 12 months to serve, 28 days, credit for time served 14 days with the balance probated, a theft class, and 40 hours of community service, and a stay away from 2525 Riverdale Road.
Yes,
What
Your
is
Honor.
what is 2525 Riverdale Road? What business is that?
Just a moment.
All right, while you get that for me, go ahead, Mr. Finley.
Yes, Your Honor. That is our understanding of the state's recommendation. We would just ask that once Mr. Boykin does complete that theft class and the 40 hours community service, if the balance of the probation could either be terminated or be non-reporting, Judge.
And Your Honor, that's Piercy's Auto Service. Percy's, my apologies.
Okay, thank you. Mr. Boykins, it's my understanding that you wish, yes, Mr. Finley, Mr. Boykins has a question.
Yes, Mr. Boykins, if it's about the facts of the case, sir, I would advise you not to say.
Excuse me, sir.
Mr. Boykins, you have a right to remain silent. Anything you say can be used against you. If you have a question regarding the terms of the plea, I'm happy to let you speak with Mr. Finley. And if you just have an issue as to where you need to stay away from or something of that nature, then let us know.
Just to make sure you understand, Mr. Boykins, this is the plea offer that we talked about yesterday that was time served and then probation. But I am asking the judge that once you complete those conditions, if the probation could be not reporting or terminated. That's what we talked about yesterday, sir.
Yes, sir.
Okay, apparently he still has a question. What's your question,
Okay.
sir?
I got time, sir, right, sir?
Keep your mask on for me.
Yes, it's going to be a time served plea.
Thank you, sir.
Okay, all right. That's your understanding, Mr. Finley?
Yes, Your Honor. That's our understanding of which we agree and stipulate the factual basis, ID, and venue.
Very good. Mr. Boykins, it's my understanding you wish to plead guilty to loitering and theft by shoplifting. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
Was that yes?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the guilty plea as negotiated, Mr. Boykins. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms, meaning once you do the theft class and once you complete the 40 hours of community service, the probation is going to terminate, okay?
One more question.
Okay. What's your question?
I guess I'll get, last time I released the bond.
You gotta keep your mask on your face.
Okay. No, you're not getting a signature bond because this is a guilty plea. So,
Add on 3.
okay. Any other questions, Mr. Boykins?
No.
All right. Good luck to you, sir.
So, Lieutenant, I released it yesterday, right?
You done.
Time served, right?
Yeah.
All right, thank you.
Position 15, Mr. Johnson.
Who's on for probation for me today?
Time served, right? Lieutenant.
I am Judge. How you doing? Good morning.
Good morning. Just let us know that we would normally do it, that you would put things in the chat if you needed something from the court regarding information. So I don't know how we're doing it today, but just let me know if there's something that you're gonna need, okay?
Okay, so I thought you said that to do it at all and for them to have their contact paper so we can have contact information
Okay.
from the last. So that's what I'm just waiting on contact information. I don't even have one from the 29th either, so just put it in there.
All right. So let's make sure that we get the contact information for everyone that's going on probation today, please. All right. Thank you. I just wanted to make sure.
Oh, and I'm sorry, sir. Your Honor, for the homeless, they have to report, but within 48 hours because
Okay.
we don't have a contact for them. If
Okay,
we
so
don't have a contact.
All right. Last time we weren't doing that because they were, people were flooding in. Within the 48 hours.
We don't have a choice because if they leave and we don't have no information on them, then they just out there.
Okay, so you want me to ask them to report within 48 hours now?
They'll be
Okay.
all right, yes.
Okay,
Thank you.
I'm happy to do that. All right, thank you.
Mhm.
All right, I'm sorry, tell me again who we have.
I believe we're at position 15, Judge.
All right, thank you. This is Mr. Johnson.
I'm sorry, I didn't know I was muted. Yes, position 15, Mr. Johnson.
Okay, thank you. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, Mr. Johnson? Do you swear upon the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Ms. Duncan.
Yes, for the record, Your Honor, this is a negotiated plea for the charge of simple battery family violence. The state is recommending 12 months to serve, 32 days. Credit for time served, 16 days, with the balance probated. No further contact with Trebia Perry. We have it spelled as Traebbya. Last name Perry, common spelling, and a stay away from 1456 South Gordon Street, Southwest, and a family violence intervention program.
Mr. Finley.
He might be frozen, Your Honor.
Well, I hope so. All right, so Mr. Finley is, let's give him a moment to log off and log back on. Courtroom 2, Mr. Finley's cases are 1 through 15. Do we have anyone 16 through 30 that we can go to while he is trying to get himself together? Oh, here he is. Here he is. You back with us, Mr. Finley? Mr. Finley, can you hear us? Can you hear us?
I could text him, Judge. Give me a second.
Okay.
Some edits is ready. Edits is ready, Your Honor. You just have one.
All right, so we're
That's
right.
mine, Your Honor.
I apologize, Your Honor. My internet dropped, I think, in the middle of that last position.
Okay, okay, so we are still on Mr. Johnson. We've gone through the terms. Do you need those repeated for you to make sure? Or did you get that part?
No, Your Honor, I believe I heard that part. We were just going to ask the court to that once he does complete the family violence class, if probation could either be terminated or not reporting, Judge.
I won't terminate it, but I'll let it go to non-reporting when he's complete.
Understood.
All right. So if we can unmute Courtroom 2, please. Thank you. Mr. Johnson, it's my understanding that you wish to plead guilty to simple battery family violence. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your guilty plea as negotiated, Mr. Johnson. I'm going to waive the probation fees for you while you're on probation. And once you complete the family violence intervention program, I'm going to allow it to go non-reporting, which means that you won't have to report, but you'll still be on probation, but just not reporting. Okay.
I just got one question. Does this mean when it said that the sentence is suspended, that mean I'll get to go today?
The sentence is not suspended. You're getting 12 months to serve 32 days, credit for time served 16 days, which means that if you get 2 for 1, that you'll be getting out today.
Okay, thank you.
Okay, that's your understanding?
Yes, that's all I want to know, sir.
Okay, all right, that's fine. Good luck to you, Mr. Johnson.
Okay, thank you.
Courtroom 2, let me go to the South Annex since they only have one, and so that we can let them go.
I apologize about that, Judge, by the way.
I mean, I know it's going to be storming today, so we might have some issues, so that's not a problem. do we
Position
have?
20, Ms. Powers.
This is also a negotiated plea. Good morning, Ms. Powers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Ms. Powers? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Put your hand down, ma'am. Ms. Webb?
Yes, Your Honor. In Ms. Powers' case, the state is recommending 12 months to serve, 30 days. These charges will run concurrent, Your Honor. Credit for time served, 19 days. Balance probated. A stay away from the country hearth and inn at 6710 Shannon Parkway, Union City, Georgia, on a 4-week anger management course, Your Honor. Nothing further.
Yes, Your Honor, that is our understanding of the recommendation. We agree with the recommendation. We would just ask, Your Honor, if after she completes those 4 anger management classes, it either be terminated or non-reporting. And I do believe that you're gonna waive her probation fees, Your Honor. And we do stipulate to the factual basis, venue, and ID.
Ms. Powers, it's my understanding that you wish to plead guilty to simple battery against a police or detention officer and criminal trespass and disorderly conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Powers.
Thank you.
I will waive the probation fees while you're on probation. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Thank you, sir.
All right, good luck to you, Ms. Powers.
Thank you.
That'll
Thank
be
you,
all
Judge.
South Annex.
Thank
All
you.
right, thank you, South Annex. We'll see you this afternoon.
Yes, sir.
Okay. Who do we have in courtroom 2?
This is Mr. Long. He's an add-on
Okay,
on 2.
and who's representing, is this your case, Mr. Finley?
I am, Judge, but I was not able to speak with him yesterday. They wouldn't let me see him, so I would need to speak with him before, Judge.
So can we get Mr. Finley to call the jail and speak with Mr. Long, and then maybe we can go to someone that's
Actually, I apologize. This is a conflict. My bad. So this is a
this is not your
conflict.
case.
It's not my case.
Okay, do we have a conflict attorney on today? All right, so let's see, Ms. Lewis, are you there?
Yes, Judge, I'm here.
Do you know if we plan on having any conflict attorney present today?
At this point, no, I'm not aware of.
Yes.
Let me double check and see if there was a request put place in for one.
Do we know who his attorney is supposed to be? Attorney C. Lewis.
I think Mr. Creel Lewis was fine today for him. Let me double check that.
Okay, if that's the case, would you contact Mr. Lewis and see if he can join us so we can deal with Mr. Long, please?
I sure will.
Okay, thank you. I appreciate that. Let's see, courtroom 2, can we go to someone else and we'll try to get Mr. Long's attorney present, okay?
Position 28, White Whitmere. Judge, we're going back to Mr. Long, correct?
Yes, we'll have to come back to him once we can get his attorney present. Mr. Whitmer, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? You swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Webb?
Yes, Your Honor, this is going to be a negotiated plea. The state is recommending 12 months to serve 40 days, credit for time served 20 days, family violence intervention program, no further contact with the victim is Shamika Smith, that's Shamika, Shameka Smith, common spelling, third-party contact with the minor child, and a stay away from 2265 Perry Boulevard, Atlanta, Georgia. Nothing further, Your Honor.
Yes, Your Honor, that is our understanding of that recommendation. We agree, and we stipulate to the factual basis, venue, and ID. We would just ask that you waive those probation fees, which I believe you're going to do. And if it is possible, once he completes those family violence intervention program classes, could it be possibly non-reporting?
Mr. Whitmire, it's my understanding you wish to plead guilty to simple battery, family violence, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Whitmire. I am going to waive the fees for you while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, it'll go to a non-reporting status. Do you and Ms. Smith have children together? Is that correct?
Yes, one child.
Okay, so you understand that you can have contact with your child, but you just can't have any contact with Ms. Smith. So you're going to have to go through a third party to arrange for visitation to see your child, okay?
Yes, sir.
All right, good luck to you, Mr. Whitmire.
Thank you.
Next, we have position 4 and 5, Mr. Cunningham.
It's gonna be a bond hearing. Let's see, Mr. Finley. Mr. Finley.
Sorry, was on mute. Yes, Your Honor, this will be a bond hearing.
Okay, and it needs to be an arraignment also?
Yes, Your Honor.
All right. Good morning, Mr. Cunningham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Mr. Cunningham, you've been charged in case 22 CR 001362G with obscured or missing license plate and driving while license suspended or revoked. And you've been charged in case 21 CR 000035G with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Cunningham? Guilty or not guilty? Mr. Cunningham?
Guilty.
It's my understanding that you were going to enter a not guilty plea to these charges today, Mr. Finley. Do you need to speak with him?
Yes, I would need to speak with them, Judge. These are, Mr. Cunningham, the offers I told you about yesterday. And you stated you wanted to plead not guilty and we would cover bond for you.
Oh, yeah, for simple battery, yeah, I want to plead not guilty.
Okay. What about for the obscured or missing license plate and the driving while license suspended or revoked?
Guilty.
Wanted to, yeah, if we could, that'd be a negotiated plea for those. But the bond hearing regarding the battery family violence.
All right, so why don't we do this? Why don't I go ahead and do the guilty plea for position 4 first, and then we'll come back to the bond hearing after that, okay?
Understood.
Mr. Cunningham, it's my understanding that you wish to plead guilty to obscured or missing license plate and driving while license is suspended or revoked. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, the terms of the negotiated plea were 12 months to serve 25 days, credit for time served 25 days, balance suspended. Is that correct, Ms. Duncan?
Yes, Your Honor, that is correct.
That was your understanding, Mr. Finley?
Yes, Your Honor, that is our understanding, of which we agree.
All right, so that will be the sentence of the court. Going on to position 5, case 21 CR 00035G, the battery family violence. And it's my understanding. You have a question, Mr. Cunningham?
We having a bond hearing today?
Yes, that's what I'm doing right this moment. Okay.
I'm sorry.
All right. So, Mr. Cunningham, it's my understanding that you wish to plead not guilty to the battery family violence. Is that correct?
Yes.
Okay. I issued the bond for the battery family violence on January 5th of this year. It was a $5,000 good bond. Mr. Howard, can you give me the history, please?
Hey, 22 total. Hold on. Got 6 probation violations in this history. 2013, 2018 FTA. Appears to be on probation for 2 counts of burglary, and the second degree, 3 counts. 3 counts theft by taking, possession of marijuana with intent, possession of a controlled substance in a drug-free commercial zone. I saw a 2018 simple battery arrest out of DeKalb County. He got a lot of probation violations. And I see a March 2021, 2 counts of ag assault, 2 counts forgery in the first degree out of Doraville.
What year were the ag assaults?
2021. Hold on. March. I think that's what I saw.
Are those open?
Yeah, March 8th, 2021. I'm not sure. They appear to be, but I'm not sure.
Anything further?
No.
All right. Ms. Duncan?
Yes, Your Honor. In addition to the history, the pretrial has stated there is no material change in fact or circumstances other than the fact that this defendant was set for jury trial on March 9th, 2022 in front of Judge Mathers and failed to appear. And at that time, the surety bond that you set was converted to a cash bond. It is the state's position that that bond should remain as stated due to this defendant's failure to appear, criminal history, and risk of reoffending.
Okay. What is the amount of the cash bond?
5,000 cash.
And Judge Richardson, was it Judge Richardson? I'm sorry, Ms. Duncan.
It was Judge Mathers.
Judge Mather, okay. All right. Mr. Finley?
Yes, Judge Morrow. We are asking for a bond modification for Mr. Cunningham. Mr. Cunningham just has 0 chance to make that bond or come even close to making that bond. And that is why, Judge, we are asking for a $2,500 surety bond or a signature bond on behalf of Mr. Cunningham. He has an 8-year-old daughter who he needs to get out and help support and be with. He does have a job awaiting him, and his boss already said that he still has that job. So we are asking once again, Judge, for a signature bond, or if not inclined, a surety bond not exceeding $2,500.
What I have not heard is why he missed that court date.
he did not have notice. He did not stated if he would have known, if he knew that he had court, he would have been there. It's Your Honor.
Okay. If Mr. Finley, if you get me some information that that he did not get proper notice for the jury trial date, I'm happy to reconsider this. But at the present time, this is Judge Mather's case. He converted this bond that I set from a signature, from a good bond to a cash bond. If there's some evidence that that he didn't get notice, then I'm happy to reconsider it. But until I get that evidence, then I'm going to leave it at where Judge Mather set it.
Understood.
All right. So if you want to put him back on at a later time, if you get information regarding,
Yes.
that, I'm happy.
Yeah, if we could.
Okay, that's fine with me. Your client has his hand up, Mr. Finley.
Can I speak with Mr. Finley real quick? 'Cause I didn't get no notice, John. I had got evicted from that house. They got the return notice. I never knew I was supposed to be in court March the 9th.
Okay, so the problem with that, Mr. Cunningham, is that once you change locations, it's your responsibility. You know that you're out on a bond. It's your responsibility to inform the court that you have relocated.
I was evicted from the house. So it was kind of, I was in a rush.
Okay, so regardless of the circumstances, it's still your responsibility to inform the court how you can get notice. All right. So.
Okay, so can we just handle this today? Like, it's the guilty plea still on the table. I plead guilty. I get time short. Like, can we just handle this today?
You want to talk with the
I don't really got time to keep going back and forth with the court, Sean. Like, to be honest with you, I really don't have the time.
Mr. Cunningham, do you want to speak with me?
Yeah, can I speak with you, please?
And we can, okay, no problem.
I don't have 5,000. I don't.
I understand.
So if you will call Mr. Finley and Courtroom 2, if we could go to positions that are 16 through 30, that are Ms. Helen's cases.
McCoy, position 16.
Mr. McCoy, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. McCoy, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you cannot afford an attorney, then one will be appointed for you. It's my understanding that you have been offered an attorney to assist you this morning, but you wish to proceed pro se, meaning that you wish to proceed on your own. Is that correct?
Yeah, I was told by the attorney that they were unable to proceed with me. So it was either this option or hire a private attorney, which I can't afford. So yes, I agree.
Okay, so let me just make sure, Mr. McCoy. Ms. Helen?
Yes, Your Honor.
He did not qualify for the public defender services?
Your Honor, he wants to enter in some legal pleas today that would be against his best interest. So against the advice of the public defender's office, he would like to proceed on his own to accept the offer here today, Your Honor. So I said that he would be able to do that. However, he'd have to be pro se.
All right. So, Mr. McCoy, you'd rather proceed pro se without the advice of Ms. Helen, even though Ms. Helen would be able to speak for you and possibly do a non-negotiated plea? Can you come back on for me, Ms. Helen? I want to make sure that we're all here for this.
From my understanding with the conversation yesterday was I was offered, she advised me of what the state was offering. And then told me that if I chose to accept that plea, that she could not represent me. And I didn't really hear any other information about what else was going to happen. Basically, the only information I was given was either bond out, which I can't afford at the moment, or I would have to wait incarcerated until a trial calendar came up. And I've been incarcerated for 114 days. I came from DeKalb County before I was here. I was in DeKalb County for over 100 days. So
Oh,
the plea that the state is offering is fine by me, just so I can get back to life and get back to work.
Ms. Helen, what did you have an objection to?
Judge, due to his history, accepting another guilty plea of a DUI would be very harmful to him, would have a lot of ramifications. However, he expressed to me that he would like to accept the state's plea to get out. However, it would have a lot of ramifications legally for him, his license, different things like that. And so I told him, I said, hey, if he would like to accept the plea with those conditions, he can do so.
All right, so Ms. Webb.
Yes, Your Honor. Would you like me to read the state's recommendation for the record?
Yes, I would, please. Thank you.
Yes, Your Honor. For the DUI charge, this would be the third DUI conviction, Your Honor, that the defendant has had since 2014. The state is recommending 12 months to serve, credit for time served 9 days, 12 months to serve 30 days, credit for time served 9 days, with the balance probated, $1,000 fine, 240 hours of community service, alcohol drug evaluation and treatment, DUI risk reduction course, 1 VIP course, ignition interlock on his vehicle, 1 alcohol awareness class per week, no alcohol or drugs while on probation, Your Honor, with random testing. For the obstruction charge, it'll be 12 months per more mandatory probation to run consecutively with 1, I believe this is an anger management class per week, and no alcohol or drugs with random testing. For the driving with a suspended license, we will offer him a time served plea, as well for the possession of an open container. That will be a time served. For the failure to obey traffic laws, which he has 2 counts, Your Honor, in a reckless driving, all of those charges will merge with the DUI charge, Your Honor.
And just one clarification, it's alcohol awareness is AA meetings?
Yes, AA meetings, yes.
So the 2 failure to observe and the possession will merge into the DUI?
The failure to obey traffic laws and the reckless driving will merge into the DUI. The possession of the open container and the driving on suspended license will be time served, Your Honor.
All right. And what's the present bond?
I saw that it was 8,000. I couldn't verify the type, whether it was surety.
Do we have the bond?
I see that he has, I believe it is a split bond, Your Honor. For the obstruction of law enforcement officers, he has $1,000 signature bond on both of those obstruction charges. He has a $500 signature bond on the 2 traffic laws. He has a $500 signature on the open container. He has a $1,000 signature on the reckless driving. He has a $1,500 surety on the DUI and a $1,000 signature on the license suspension.
1,000 on license suspension?
Yes, Your Honor. And it's 1,500 surety on that DUI.
What are the conditions?
Let's see, 1 second, Your Honor. I believe his only conditions was no alcohol, drugs, or weapons, and no driving. Let me just double check. Yes, Your Honor. Those are the only 2 conditions that I have. If PD Helen has anything additional. I don't see anything additional.
All right, nothing further, Ms. Helen, that you see?
No, Your Honor.
All right, so, Mr. McCoy, here are your options. You've heard what Ms. Helen has said regarding your case. I believe that they are willing to represent you. They don't believe that the terms are favorable for you. So today you can either go pro se and enter into a plea. If you would like for me to consider a bond modification so that you would at least be able to get out and come back and speak with Ms. Helen in more depth about what these charges will mean for you down the road, I am happy to consider that also.
I mean, yes, Your Honor, that'd be favorable if I could have a bond reconsideration and, that'd be preferable.
Okay. I understand Ms. Helen's concerns regarding your matter. As such, what I'm going to do is I'm going to convert your surety bonds to signature bonds. These are all going to be through the jail. You can have absolutely no driving.
Yes, sir.
Okay, so although I'm gonna allow you to get out and come back and deal with these charges, absolutely no driving, absolutely no drugs, no alcohol or weapons while you're out on bond. Okay.
Yes, Your Honor.
And Your Honor, if I may just put on the record, the defendant has FTA'd on these charges previously. In addition to, Your Honor, he does have a DUI conviction out of Fulton County from 2017, as well as another from Atlanta out of 2014, as well as a probation violation from DeKalb from 2018, which I believe is where he just came from serving time from, and the same from Lamar County from 2010.
Okay. So you understand, Mr. McCoy, that if you do not show up, these bonds are going to be revoked and you're going to be right back in the same place that you are. You understand that?
Yes, Your Honor, the address that was somehow mistranscribed, Miss Helen, when she spoke to me yesterday, read off the exact address that I've lived at since 1993, but it was mistyped as, and the name of the road was Road instead of Bend. So, and my identification that I've had since I'm 16 years old has been Bainbury Bend, not Bainbury Road. And even Miss Helen has the documentation right there that the notice was sent to an improperly typed address. That is I know it's my fault, I guess, in the long run, but had I known that I was supposed to be in court on September 27th, I definitely would have appeared. And I do understand your stipulations of no driving, and I do understand that if I do miss the next court date, it will be not good.
All right, so Ms. Helen, let's make sure that we have Mr. McCoy's proper address with the clerk's office. If you'll do that bond modification for me and
I was just going to ask if I could just have the breakdown of what you guys show representing of each charge, just so I can make sure I have the modification correct. The DUI is a 1,500 surety.
Yes. And Your Honor, in addition to, I was just made aware as well that the defendant has another DUI conviction from Clayton County from 2009. So I just want to put that on the record as well.
Thank you, Ms. Webber.
And the possession of the open container, what's the bond for that?
Open container is a $500 signature bond.
And the obstruction?
Obstruction is a $1,000 signature bond.
Okay. And Judge, I'll submit that to the court.
So excuse me, I'm sorry for interrupting.
Yes, sir.
So the surety bond, the bond that wasn't surety for the DUI is going to go to signature bond, is what you're saying, Your Honor?
That's correct.
For all these signature bonds?
That's correct.
Thank you, Your Honor.
And Your Honor, if I could just say briefly, now that we know that this is his fourth DUI, I just want to put the PD on notice that we're sending it to the DA's office.
This is the third.
Hold on, Mr. McCoy. Okay, we'll follow up with that, okay?
But I heard the city of Atlanta, Fulton County, and Clayton County convictions, which will make this his fourth. But I just want you to be placed on notice so there won't be any surprises.
Yes, sir.
The one that was City of Atlanta was transferred. There's the Clayton
Oh,
County.
Mr. McCoy, we're not going to talk about your history here. We've taken notice from what Attorney Walker has said, but we're going to move on to the bond modification you now have, okay?
All right. Do we need anything further, Ms. Helen?
No, Your Honor, I'll submit that to Ms. Middlebrooks.
All right. Thank you. Good luck to you, sir.
Thank you.
What do we have next?
Position 18, Muniz.
Good morning, Mr. Muniz. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. It's my understanding this is going to be a negotiated plea. Is that correct?
Yes, Your Honor, it is. And for Mr. Muniz, the state is recommending 12 months to serve 30 days, credit for time served 16 days with the balance suspended with a stay away at 127 Peachtree Street, Atlanta, Georgia.
That is our understanding of the state's recommendation. We agree. We stipulate to the factual basis, venue, and ID.
Thank you. Mr. Muniz, it's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Muniz. Good luck to you.
Thank you.
Can we go back to Mr. Long? Mr. Lewis is here on that case.
I am, Judge, but not ready. If you
Okay.
could- Yes, sir. Good morning
All
to
right.
you.
Good morning. All right, we appreciate you joining us this morning. So
Yes, sir, and I apologize, Miss. They told me about this case on the 31st, and my folks didn't get it on my calendar, so that's my fault, and I
okay,
apologize.
that's
for
fine.
that.
Do you need to speak with your client or?
I do. Which courtroom is he in, Judge?
He's in courtroom 2.
Understood. I'll reach out to him now. Thank you.
Okay, very good. Thank you.
Yes, sir.
This is position 13 and 14, Mr. Hudson.
Okay. Mr. Filling, I have hold for announcement.
Yes, Your Honor. Mr. Hudson is going to be a non-negotiated plea, Judge.
Okay. Good morning, Mr. Hudson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Let's see, Mr. Howard, do we have a history for Mr. Hudson?
Yeah, I do not see it in the system. I got a Martavius Hudson. Yeah, it would have to be generated.
Okay, so let me get back with you then. Ms. Duncan?
Yes, in this case, Your Honor, the state would have been recommending 12 months to serve 60 days, credit for time served 16 days with the balance probated, a family violence intervention program, no further contact with Delicia Hudson, a stay away from the 2060 Allison Court Apartments, B3. And for the second charge, we'll be recommending a 12 months to serve 60 days, credit for time served 12 days with the balance probated, no further violent contact with John Wesley Hudson, family violence intervention program, 60 hours of community service, and we will have that simple battery charge merged with the first charge. Here, Your Honor, we have the facts in the first. How would you like me to proceed, Your Honor?
Yes, I'd like the facts for both those cases, please.
Okay, so for the first case, the battery family violence that occurred on March 6, 2018, Officers arrived on scene and they were flagged down by the victim in that case, Delicia Hudson, while at a traffic stop at the intersection of Myrtle Drive Southwest and Allison Court Southwest. She stated that the defendant, Mr. Hudson, was her boyfriend who she lived with at the time, had punched her in the face with a closed fist, and she had a swollen lip and a cut on her left cheek on her face. Officers were able to observe the injuries on the victim's face and went to the location of 2060 Allison Court apartment B3, I believe, and they placed the defendant into custody. Would also like it on the record that this defendant was released initially for this charge on May 7, 2018 on a $2,000, there's a $2,000 cash only bond that I see and a $750 good bond to have no further contact with this victim and to stay away from that address. This case is currently in front of us because of a bench warrant from a jury trial from June 2021. For the next case, 19 CR 005457Y, officers arrived on scene and there was an incident between the defendant and his father, Mr. John Hudson, about money, and there was a tussle that ensued between them. And Mr. Hudson, the father, put his son in a headlock to prevent him from hitting him again because the defendant had punched his father with a closed fist. The father stated that he only did that because his son had become very aggressive and he was protecting himself. Your Honor, the facts additionally in this case were there was a bond forfeiture in December of 2021. And on this case, the defendant FTA for jury trial in December 16th, 2021 as well. And I believe I requested, let me see where we are with the criminal history. Since this is a rearrest from 2017, it was not in the system, but let me just check. One moment. Either way, Your Honor, the state will request that the bond remains as set.
Well, I understand this is a non-negotiated plea.
Right. Let's see. Yes, we have it, Your Honor, as 5 cycles in terms of the criminal history. Starting in 2012, there's an arrest for giving false name and address, no disposition. There is a furnishing to purchase of or possession of by persons below legal age of alcoholic beverages in October 2012. There is a battery arrest from 2018, which is this one, which is one of the ones in front of us. And there is a battery charge from, I'm sorry, there's a simple battery family violence from May 6, 2018, which is what's in front of us. And then after that, there is a willful obstruction of law enforcement officers and a terroristic threats arrest that was made in November of 2020. And that is all we have as far as criminal history. Record indicates that this defendant has also been detained on these charges as stated, a total of 15 days and 12 days respectively. He's currently being, let me see. These are, yes, they are rearrest. So the bond is set at $6,000 cash only.
Okay, so you're giving him time, you're giving him credit for time served 27 days?
Well, we split it up separately since there were different victims. So for the first one, 18 CR. Yes, for the first one, 18 CR 0049555Y, we are recommending 12 months to serve 60 days, credit for time served 15 days, balance probated, family violence intervention, no further contact with Delicia Hudson, the victim in that case, and to stay away from 2060 Allison Court, apartment B3. We are requesting that amount of time due to the facts as related. This defendant FTA for trial.
For trial on both?
Yes, we have an FTA on jury trial for both of these charges.
Okay. And when he was in jail initially, was he in jail he's been in jail this time for 12 days, is that right?
Let me clarify, Your Honor, one moment. On this rearrest, he's been in jail 12 days, Your Honor, yes.
Okay, and he was rearrested on both these charges?
He was rearrested on a bench warrant for the family violence case from May 6, 2018, and rearrested for the February 13th, 2018 charges.
Okay, and when he was in custody the first time, the first 15 days, was he in custody for both these charges?
No, on the initial incarceration, which gave 3 more days to the charge from May 6, 2018, I only see that he was in custody for 3 days on that charge. And that there was an additional charge added, which is a part of the current booking for the February 13th, 2018 charge. He has only served 12 days on that second case from February 2018.
Okay, thank you, Ms. Duncan. Mr. Finley?
Yes, Your Honor. And I just want to make sure I understand correctly. So because this is 2 different victims, it's going to be, they're asking for 18 days separately for one, and then they're not going to run concurrently. Is that correct?
What you say, Mr. Finley? My apologies.
Yes, Ms. Duncan. I just want to verify. So the time isn't going to run concurrently. So it's 18 days plus 15 days for the other.
Mr. Finley, it's credit for 15 days on the first charge, and the recommended is 60 days. And for the second charge is 12 days on that charge and 60 days served for that second one, since there are 2 FTAs. So we would ask that they run concurrently.
Yes, Your Honor. I'm asking for time served on behalf of Mr. Hudson. I did speak with him regarding those FTAs. He states, this is what he told me, that he updated his address in 2019, that he did not receive any type of notice. And if he did receive notice, he certainly would have been there. That's what he says. But according to him, he did update his address, but still they sent it to the wrong address, supposedly. Additionally, Judge, I just hope Your Honor can factor this in. I have verification from his dad that he did complete a family violence intervention course since these arrests happened. It is in my email, and I can send it to the court if need be. His dad sent it over to me. But once again, Judge, we are asking for time served on behalf of Mr. Hudson. He's a man, works security. Leading up to this happening, he has 2 daughters and looks forward to getting back to work and helping support those young daughters.
I'm sorry, Mr. Finley, what did you say that his father had information on?
Yes, Judge. His dad sent me a it's like a progress report. It was completion of a family violence class that he says he completed since this incident happened back in 2018.
Okay. Anything further, Mr. Finley?
Nothing further, Judge.
Mr. Howard, did you ever get the history?
It being generated.
Okay.
You're gonna go off of the state or?
I'm gonna go up Ms. Duncan's history. Anything further, Ms. Duncan?
Yes, we would just like to add that his father was in fact the victim in that 2018 case, and we are aware of his wishes for no violent contact. However, given the status of the case and the facts as stated, we just stand on the position we stated to the court.
And
And the position that you made is, I mean, you initially recommended no further violent contact with Mr. Hudson. Is that
Yes.
the position you're standing on?
Yes, they're two separate victims in two separate instances.
Right, I understand that.
so it's no further violent contact with his dad, correct?
Yes.
Right.
Okay. And just one last thing, Judge Morrow, I'm looking at it right now. The domestic violence course was 24 weeks, of which he did complete, looks like on December 23rd, 2019.
Okay, so I'm going to take that into account for the incident with Mr. Hudson. He's still going to have to complete a family violence intervention program for Delicia Hudson. Okay. All right, anything further from counsel?
Nothing further, Your Honor.
Nothing further, Judge.
Mr. Hudson, in case 18 CR 004955Y, battery family violence, it's my understanding that you wish to plead guilty to that charge. Is that correct?
Yes.
And in case 19 CR 005457Y, battery family violence, it's my understanding you wish to plead guilty to that charge.
Yes.
Is that a yes?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I have something to say, but other than that, yes.
Oh, okay, so again, Mr. Hudson, you have a right to remain silent. Anything you say can be used against you. My question.
Yeah.
Mr. Finley?
I was just going to say to Mr. Hudson, if it's regarding the facts of the case, I'd strongly advise not to say.
So it's my understanding, Mr. Hudson, that you're satisfied with the representation that you've received from Mr. Finley. Is that correct?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your guilty pleas in both these cases, Mr. Hudson, for position 13, case 18 CR 004955Y, battery family violence. The sentence is going to be 12 months to serve, 30 days, credit for time served, 15 days, balance probated, a family violence intervention program, no further contact with Delicia Hudson, and stay away from the 2060 Allison Court, apartment B3 address. The sentence for case number 19 CR 005457Y, battery family violence. The sentence is going to be 12 months to serve, 24 days, credit for time served, 12 days, balance probated, no further violent contact with John Wesley Hudson, 60 hours of community service, and no drugs, alcohol, or weapons while out on bond on both cases. The second case is going to run concurrent with the first case. I'm going to waive the probation fees for you while you're on probation, but I'm going to require that you be on probation for the entire 12 months. All right. Any questions, Mr. Finley?
No, Your Honor. Thank you.
All right, Mr. Hudson, good luck to you. Yes.
Position 1, Mr. Aaron.
Good morning, Mr. Aaron. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, sir. Ms. Duncan?
Yes, Your Honor. For the record, I have this indicated as a negotiated plea. Under the terms of the negotiated plea, the state is recommending for theft by taking 12 months to serve, 58 days, credit for time served, 29 days, with the balance probated, 40 hours of community service, no further contact with the victim in this case, Rodriguez Williams, a stay away from the incident location, a theft class, and restitution.
How much is the restitution and what is it for?
The restitution would be for Timberland boots and Bluetooth speakers. We are in the process of contacting the victim. We left a message and we are waiting for his return.
All right. So since we don't have an amount for the restitution, I'm going to let the victim proceed civilly on that. I'm not going to have someone enter into a plea and not know what the actual sentence is going to be regarding that. All right. Mr. Finley?
Yes, Your Honor. That is our understanding of the state's recommendation, that it's a time served deal. We would just ask, Judge, that once Mr. Aaron does complete the community service and the theft class, if the balance of his probation can be terminated or become not reporting.
Any objection to termination, Ms. Duncan?
The state has no objection, Your Honor.
Thank you. Mr. Aaron, it's my understanding that you wish to plead guilty to theft by taking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty to this charge, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the guilty plea, Mr. Aaron. 12 months to serve, 58 days, credit for time served, 29 days, balance probated, 40 hours of community service, no further contact with Rodriguez Williams, stay away from the incident location, and a theft class. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation will terminate, okay?
Yes, sir.
All right, good luck to you, Mr. Aaron.
Appreciate it.
Position 4 and 5, Mr. Cunningham.
It's going to be a bond hearing, Mr. Finley.
This was the one that was before us earlier, Judge. This is actually going to be a non-negotiated.
All right.
Or it's a negotiated for position 4 and then 5 non-negotiated.
All right, so we've already, did we already?
Oh, yes, I'm sorry. Yes.
Yeah,
you're
we already
correct.
took the plea in
You're
4. And it's going to be non-negotiated for 5. All right, and I have already gotten his history. Ms. Duncan, let me just start at the beginning again with him, just so we have it complete on the record. Courtroom 2, if you can unmute for me. Good morning again, Mr. Cunningham. Can you raise your right hand for me again? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Ms. Duncan, position 5, 21 CR 000035G. Battery, family violence. Can you tell me about that, please?
Yes, Your Honor. In this instance, it occurred on January 4th, 2021. Officers responded to the victim, Ms. Copeland. She stated that she was in an altercation with Mr. Cunningham. And Mr. Cunningham threw her phone and took her keys and locked her out of the house. While speaking to officers, officers could see visible scratch marks on her face and blood on her lip from a cut. Ms. Copeland was asked about the marks on her face. She stated to officers that they came from the altercation because she told the defendant that he could not use her car. She went outside and sat in her vehicle to try to get away from Mr. Cunningham. He came outside and began to argue with her more and snatched her out of the car. And then the victim stated to officers that the situation escalated much more quickly at that point when he hit her in the face and caused blood to leak from her lip. She called officers and officers overheard, she called 911 and officers overheard the physical altercation on the phone when they knocked on the front door. And once they got there, there was, so they were advised that initially that they could not make entry. So once they were allowed in, they saw an unlocked back window. However, the defendant was hiding in the master bedroom closet and was detained. Given the facts and circumstances surrounding this case, they had been boyfriend and girlfriend for 6 years and living together. Given the circumstances surrounding this incident and the violent nature of the charges, as well as the defendant's criminal history with 23 arrests since 2013 and at least 7 convictions and 2 FTAs from 2013 and 1 from March 2021, which was jury trial. The state is recommending 12 months to serve, 60 days credit for time served, 25 days with the balance probated, a stay away from the incident location, 412 days to hold, no further contact with Ms. Copeland and the family violence intervention class.
It's credit for 25 days, Ms. Duncan?
Yes, 25 days.
Mr. Finley?
Yes, Your Honor. We are asking for a time served deal for Mr. Cunningham. Mr. Cunningham is a man that had a stable employment leading up to his arrest. He has employment that's awaiting him once he gets out, and an 8-year-old daughter who he looks forward to seeing and helping support once he gets out. Your Honor, he's been in jail now for, as we just heard, 25 days. They are asking for 30 days, so only 5 additional days. And we are asking for that to be converted to time served, Judge. I'm sorry. And also, once he does complete the family violence course, if his probation could either be not reporting or balance terminated.
I'm not willing to let it be either of those. He's going to have to be on probation for the entire time. Okay. Mr. Cunningham, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Cunningham. The sentence is going to be 12 months to serve, 50 days, credit for time served, 25 days, balance probated, stay away from 412 Thistle Cove, no further contact with Yasmin Copeland and the Family Violence Intervention Program. I'm going to waive the fees for you while you're on probation, but you're going to be required to be on probation for the entire 12 months. All right, good luck to you, Mr. Cunningham.
Thank you.
Position 3, Mr. Kane.
This is going to be an arraignment and a bond hearing, Mr. Finley.
That's correct, Judge.
Good morning, Mr. Kane. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning. How you doing?
Good morning. I'm fine. Thank you, Mr. Kane. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you put your hand down. Thank you, sir. Mr. Kane, you've been charged in case 17 CR 025842Y with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
Mr. Kane, how do you plead to this charge, guilty or not guilty? Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. What do you all have down as the current bond and fine?
I have down as a $4,500 cash bond.
That's what I have as well, Your Honor, because this defendant FTA for jury trial twice, once on November 14th, 2021, and again on December 14th, 2021. He was scheduled to be in Judge Edie's courtroom and failed to appear both times. And since this arrest since this initial arrest for this charge in 2017, has had a parole violation in 2018 and an additional arrest in September of 2021.
Mr. Finley?
Yes, Your Honor. We are asking for a bond modification. I did speak with Mr. Kane about those missed appearances. He stated that he was not aware of those court dates, and I really stressed to him to make sure he confirms his address with the court to make sure that doesn't happen again. Mr. Kane is someone that's been rebuilding his life over the last few years. He held stable employment at McAllister's, and leading up to his arrest, he had actually been offered a manager position and worked his way up from at one point being homeless to someone that fully supports himself. He does have a $4,500 cash bond, which he cannot afford. That bond to him is effectively a no bond because he just has no chance of paying that. That is why, Judge, we are asking for a $2,000 surety bond on behalf of Mr. Kane.
And the state would just like to note for the record, Your Honor, that this defendant initially received a $3,500 signature bond, and upon the second failure to appear, it was then converted from surety to cash as it stands at $4,500.
Okay, and that was converted by
Judge Edie.
Okay. Well, since this is Judge Edie's case and he converted the bond to a cash bond, I'm going to let his order stand. Good luck to you, Mr. Kane.
Well, I can plead guilty to the charge.
So why don't we do this, Mr. Finley? The state is requesting 90 days, credit for time served 38 days. If you want to speak with him and put this on the SAP calendar for next Tuesday,
Yeah.
I'm happy to do that.
And if we could do that, Judge, I know I did speak with him and he said
Okay.
he would want to be, yeah.
All
on
right.
an
So let's.
upcoming calendar, yeah.
All right. So let's put Mr. Kane back on the calendar for next week's state all-purpose calendar, which will be 12.
Mr. Kane, I will speak with you and then we will readdress possibly taking a plea.
All right. So we'll see you next week, Mr. Kane.
This is position 23, 24, 25, 26, and an add-on on 3.
And Judge, we requested a Spanish translator for these positions. And we requested that it be reset to this Thursday. I do believe that that was accomplished, but we needed a Spanish translator.
Miss Helen,
Yeah.
yeah, I just asked him. He said he doesn't need one.
Well, when we spoke to him, we had some breakdown in communication, so we'd be more comfortable speaking to him with a Spanish interpreter to make sure there was no breakdown. Last time we had some breakdowns with him, so we're gonna feel a little bit more comfortable with the Spanish interpreter.
Okay, so we'll reset him
I don't
for
need it.
Go ahead.
7.
I don't need interpreter.
Can I get the phone number to Courtroom Two? Give him a call real quick.
404-612-2392, but someone's on the phone now.
Understood. I'll give him a call in a sec.
All right, so let me just say that the recommendations, was this going to be a negotiated plea or what, Ms. Helen?
No, the woman.
Well, see, the thing is, when we spoke to him, I and Attorney Finley spoke to him, and there was a miscommunication whether or not he had private counsel or he was needing the public defender's counsel. So that's why we really want to speak to him with a Spanish translator.
I understand that, but I'm just saying that if the recommendation is 120 days, but if the time served 18 days, if I put it,
Hold on, Mr. Serrato.
if I put this back on my calendar for next Tuesday, it will give you enough time to do all that, and I will be able to see him since the recommendation is not a time served.
Understood, Judge.
Is that what you all want to do?
Yes, Judge. And I'll just follow up with Mr. Michael Jordan just to make sure that.
I don't need it. I don't need a interpreter.
Okay, well, this isn't so much about the interpreter, Mr. Serrato. This is more about what we're gonna do with your case, what you want to do with your case. So we're gonna reset you till next Tuesday, and you'll be back in front of me at that time.
Thank you, Judge. And yeah, I'll just follow up with Mr. Michael Jordan just to let him know that we came to that conclusion. Thank you.
Okay, thank you. All right, this is reset for next week.
Ready when you are, Judge.
Courtroom 2, we're complete with Mr. Serrato. Thank you. And it appears that Mr. Long is ready.
Logging? Oh, Mr. Long. Come on, Mr. Long.
Yes, Judge. Good morning again.
Yes. What are we doing with Mr. Long today?
I'm sorry, Judge.
What are we doing with Mr. Long?
Judge, I would like to have a bond modification on Mr. Long. We're not interested in pleading at this time to that charge.
What position is Mr. Long? Oh, he's add-on 2. Okay. And he'll need to be arraigned. Are you going to file would you like me to arraign him now? Or would you want to?
No, I'll file a waiver on that, Judge. We can see the charges. Well, we can see the charges on the calendar, and so as long as there's no departure on the physical accusation from what's there, then we're good with it. We see a battery family violence charge, Judge. Is that what you have?
That's what I have.
Good enough.
Okay, so good morning again, Mr. Long. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Long. Let's see. In case 22 CR 001581E, battery family violence, there was an amended bond order signed on March 31st of this year by Judge Law, amending the bond to a $1,500 good bond, no further contact with a PETUS, and no drugs, alcohol, weapons, or firearms. What's the history, Mr. Howard?
6 total. I don't see any violence in this history. All I see is driving. It's suspended license, suspended registration, FTA, probation violation. Everything is driving though.
Your Honor, he does have an open theft by receiving case out of Cobb too.
All right.
You got
Go
that?
ahead.
Okay, yeah,
Yeah.
from December, yeah.
Okay. Thank you, Mr. Howard. Ms. Webb, go ahead.
Yes, Your Honor. In this particular case, the facts as alleged are that this incident took place on March the 18th at 300 Deering Road. That's Deering, Deering, where the Atlanta Police Department responded to a domestic dispute call between the defendant and a Mr. Isaiah Pettis. That's Isaiah, Isayis. Pettis or Pettis, Pettus. The officer made contact with the defendant upon his arrival, and the defendant told the officer that while he was sitting on the couch with his live-in boyfriend, that Mr. Pettis came up to him and slapped the phone out of his hand. The defendant then proceeded to take a glass of water and poured it on Mr. Pettis, and then proceeded to throw that glass at Mr. Pettis. The defendant also told the officer that he left the home to cool down for a while. When he came back, the two began arguing again. And at some point, which is probably the facts that defense counsel was pointing to, there are allegations of some type of metal pole being used where the defendant struck Mr. Pettis. And Mr. Pettis alleging that the defendant struck him with the pole first, Your Honor.
Right. No, that's not right.
Excuse me, Judge, may I address my client for just a moment?
Yes, please.
I want you, sir, to be quiet and let me do this. Okay? We cool? All right. Go ahead, Judge.
All right. Ms. Webb, I apologize.
Yes, Your Honor. Yes, so there are some allegations about a pole being used. Both parties, Mr. Pettis and the defendant, alleged that both of them struck each other with that pole. The officer was able to notate that Mr. Pettis did have bleeding and scratches on his chest, and that the defendant as well had bleeding and scratches on his body. So, Your Honor, both parties were arrested in this incident. And for those reasons, the state did make that recommendation originally.
Mr. Lewis, can I talk to you on the phone?
Just a moment, please.
Mr. Long, this is how this is going to work. I'm going to allow you to speak with your attorney, but we don't interrupt people in this court. Right? That does not bode well. That does not bode well for you. Okay, and that is why Mr. Lewis has advised you to not to remain silent. Okay, so what you're doing right now, that's not helping you.
Okay.
All right. Thank you. Again, Ms. Webb, I apologize.
Yes, Your Honor. And because the officer was able to basically see that there were visible markings on both parties to show that both parties at some point were aggressive with each other, both parties were ultimately arrested in this case, Your Honor. Originally, I believe the defendant did have a $3,000 good bond that was entered on March 19th, but as Your Honor knows, Judge Law did amend that bond order on the 31st of March to a $1,500 good bond. So the state would just request, considering I believe Mr. Pettis may still be in custody, if I'm not mistaken, when I checked this morning. But the state will request that we keep the $1,500 bond with the conditions that there be no further contact with Mr. Pettis and to stay away from that 300 Deering address, and no alcohol, drugs, or weapons while out on bond, Your Honor.
Ms. Webb, the bond modification doesn't have anything about a stay away, just a no further contact.
Okay.
So maybe Mr. Pettis has to stay away from that location. I'm not sure. But just on the Judge Law's amended bond order, there's no stay away.
Okay, let me see, I believe.
Underneath the Pettis, Judge, there's a stay away for him.
Okay, all right, thank you.
I was referring, excuse me, Your Honor, I was looking at the original bond order and I saw on the original, there was no further violent contact. Yes, Your Honor.
All right. Mr. Lewis, do you need to speak with Mr. Long before we proceed?
Yes.
I mean, he's visibly agitated. So.
I know. Do you want me to do it on a breakout, or you want me to do it just?
Let's do it by phone if you don't mind, so I can continue with the calendar. Okay, so if you'll just
we're calling right now. I'm going to mute you out, Judge, just so I can have this conversation.
Okay, I understand. All right.
Thomas Phillips. Position 19, Mr. Phillips.
Oh, there's no weird delay time.
Okay, so this is a negotiated plea, is that correct?
Yes, Your Honor, this is a negotiated plea according to my records.
Good morning, Mr. Phillips. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me?
Yes, I did, yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
No.
Yes.
I just want to.
Okay, thank you.
All right. And I,
Courtroom 2, can we get you all mute while we go through this? Thank you. Ms. Webb?
Yes, Your Honor, the state is recommending a 12 months to serve 30 days, credit for time served 18 days, balance suspended, and a stay away from the 5 Points MARTA station located at 30 Alabama Street, Atlanta, Georgia. Nothing further, Your Honor.
Yes, Your Honor, that is our understanding of the state's plea. We stipulate to the factual basis, venue, and ID.
So he can ride MARTA, he just can't go through the 5 Points MARTA station.
That is correct, Your Honor. I believe he did have a notice of suspension from that station as well, so for a stay away.
Okay, now if we can unmute Courtroom 2, please. Are you with me, Courtroom 2?
Back with you when you're ready, Judge.
Okay. We're in the middle of a plea. As soon as I can get Courtroom 2 to come back.
Yes, sir. Yes.
Courtroom 2, we're ready whenever you all are.
I'm sorry, Judge.
Okay, that's fine, thank you. Mr. Phillips, it's my understanding that you wish to plead guilty to criminal trespass, willful obstruction of a law enforcement officer, and certain acts on a bus, rail station prohibited, is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
Is that a yes?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Judge.
Has anyone forced you or coerced you to plead guilty, Mr. Phillips?
No, Judge.
Okay, I'll accept the plea as negotiated. You know you can't go back to that 5 Points MARTA station, right?
Yes, sir.
All right, good luck to you, Mr. Phillips. Okay, let's go back to Mr. Long. All right, Mr. Lewis, any argument on the bond modification?
Yes, Judge. First and foremost, Judge, the last time I was before you in an unrelated case, I brought up the case of Capacity for a reason. When things are being relayed to you that are not germane to the bond at this particular point, it brings about all of this additional stuff from defendants, people who were actually there. And so I'm going to ask the court to strike all of that information that is obviously not in the warrant. If we accept it as true, Judge, then we would accept the fact that my client is responding, if we accept the facts that have been relayed by the state, my client is responding to someone having slapped him. And so now we don't have a battery at all against this particular person. So I'm not asking the court to judge the facts, but I am asking the court to not take into account any of that recitation. What is important at this particular point is that my client does have one failure to appear that we've heard about. It is a failure to appear that was born of the fact that he reached out during COVID and alerted the court or alerted some court official who I can't identify right now because he doesn't have his phone, that he wasn't able to make it to court on a date. And he did that 3 days in advance. And as a result of that, he has a failure to appear on his record. My client's bond was reduced by Judge Law, but he's still in custody. And he's in custody because of difficulty associated with bonding company requirements, not because of any other reason. Just bonding companies have their own things that they need to be assured about everything. And apparently they're not getting it from the people on the outside. And so since they can't get it from the people on the outside, he's still sitting in front of you. He doesn't have $1,500 to put down. My client has no problems abiding by the conditions that Judge Law laid out. And Judge, if you want to impose an additional condition that he stay away from this particular residence, we would have no objection to that either. My client does have an address other than that to reside at, and he can reside at that address. In fact, that address belongs to his brother that lives in this state. So he's got community ties to the state, and he's lived in the state of Georgia for the last 4 years. As we've heard from pretrial services, he has no acts of violence in his past, none. The state offered that he had a case pending involving some theft-related event in Cobb County, but that's it. And so I would ask the court at this particular point, and you know, the last time I was before you, I was confused about whether UJR was the appropriate language or SOB was. But at this particular point, Judge, we're asking the court to impose either a UJR or an SOB with the appropriate conditions that it believe are necessary to bring this man before the court again to ensure the safety to victims and witnesses involved. I didn't say anything about the offer, Judge, because, you know, I'm one of those people that looks at 24-4-4-10-4, which says that plea offers and things of pretrial negotiation aren't supposed to be in your purview. And the state of Georgia, through its prosecutors, have argued that vehemently when defense used to raise the fact that it was 408 that was controlling. Well, the law is the law. That information is not supposed to be in front of you. And I was surprised to see it on the calendar. But nevertheless, my client is aware of it, as I'm obligated to tell him about any offers. And he wants to reject it because the statements that are being made about him here are untrue, as well as the fact that he's an aggressor in anything. So we'd ask the court to impose a bond. We ask that bond be commensurate with the fact that he's been sitting in jail now for 19 days, not even able to get a bail bond company to get him out, and himself not having the $1,500 to put down, and let him come back in court and fight this charge in open court. I also heard Madam Prosecutor say that his co-defendant remains in jail. So that means his cross-defendant remains in jail. That means his cross-defendant probably has a similar viewpoint on these facts that you've been given. Thank you.
Your Honor, if I may respond.
Go ahead, Ms. Webb.
Yes, Your Honor. Well, first, defense counsel pointed out about facts not being in the warrant. That is incorrect, Your Honor. The warrant actually states verbatim that Mr. Deshaun Long caused significant bodily harm by hitting the victim in the leg with a pole, causing bleeding and swelling to the victim's left leg, Your Honor. Second, Your Honor, this is a bond hearing in which the court can receive any information in regards to the four Ayala factors, which in Mr. Long's case was, of course, the FTA, which he had from a case from last year, Your Honor, in addition to the risk of reoffending, and in addition to that, Your Honor, the community ties, which we did hear from the defense counsel, who said that Mr. Long does have community ties. But as far as the state's concerned, we are clearly concerned with witness intimidation, considering that both parties were arrested in this case, Your Honor. So that can be incentive for both of them to sway away or try to move the case in a way that can influence prosecution, Your Honor, as well as we do believe that he is a flight risk. We understand that COVID did present strenuous circumstances for all, but at the end of the day, the burden is on the defendant to ensure that he alerts the clerk of court as to his address, and that if there is any issues, that he reach out to his counsel, the public defender's office, or whomever may be representing him to ensure that he actually appears for those court appearances, Your Honor. That burden is not on the state, it's on the defendant, Your Honor. And as I stated before, it is indeed still proper for the court to hear the defendant's criminal history, albeit that is not violent. It does indicate that the defendant is not per se just has a clean sweep, Your Honor, and that there are open cases that are still under another jurisdiction purview, and we do not know all of those facts. And we, as in this case, we do not have all of the facts before us, but indeed we are not trying to impose any false facts. Those are all facts that were given and provided to the state by the police report and the actual warrants. So we will ask that Your Honor does not strike any information that was given to you today in court, Your Honor. Nothing further.
Let me, Judge, if I may, since it is my burden, as Madam Prosecutor identified.
Mr. Lewis, you might be talking yourself out of an SOB.
I was just going to give you the address that my client will be at, Judge.
I'm thinking that I'm going to let him go back to Deering Road. I mean, he is not. I mean, if that's his address, and he was not initially restricted from Deering Road, I'm going to allow him to go back there.
Yes, sir.
Okay, and in the notice to your benefit that I do have information regarding what the offer would have been, because it would have been a time served offer. I'm not going to keep Mr. Long in custody simply because he can't afford the $1,500 bond. What I am going to do is make it a $5,000 SOB through the jail with the condition that he have no further contact with the other alleged victim, Mr. Pettis, and no drugs, alcohol, or weapons while out on bond.
Yes, sir. He agrees to that, Judge, and thank you.
All right.
Good luck. And I will get my entry, and I won't be slow anymore, Judge.
Okay. That's fine. I'm glad we're able to track you down, Mr. Lewis.
Yes, sir. Yes, sir.
All right, Mr. Long. Good luck to you. Mr. Lewis, you're going to have to prepare that bond modification for the court.
I'm going to reach out to your staff to help me, Judge, because they know where my strengths aren't.
All right.
Thank you.
Have a good day.
You as well, sir.
Thank you.
Bye-bye.
Mr. Bullock, he's an add-on position 1.
Do you recommend I do that?
This your client, Mr. Finley?
This is my client, Judge. That's correct.
And what are we doing with Mr. Bullock today?
Yes, this is going to be a non-negotiated plea, Judge, but we are addressing the jail time.
Okay. Good morning, Mr. Bullock. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Okay, thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. Thank you. Ms. Webb?
Yes, Your Honor. For Mr. Bullock, the state is recommending 12 months to serve. Your Honor, this incident arose on November the 28th of 2021 when Union City Police Department was dispatched to the local Walmart located at 4735 State Route 13, Union City, Georgia. Upon the officers' arrival, they were met with the store's employees who informed the officers that the defendant had a weapon and that he brandished a firearm at customers during an argument in the store. The arresting officer did locate a Pro Mag Rossi model RS-22 rifle, 22 caliber with serial number 036-851. The defendant also had a magazine with 28 rounds and 58 extra rounds. When the officer ran the defendant through the GCIC, he came back with a warrant out of Jonesboro, out of Clayton County, and that the defendant was a convicted felon. Your Honor, The defendant did enter into a not guilty plea on, looks like January the 13th of this year at another SAP calendar, and bond was set at a $2,000 surety with a stay away from that Walmart, Your Honor. There was a discrepancy in the defendant's criminal history as to whether he was a convicted felon. The defendant does have a robbery charge out of Brookhaven from 2019. But at the time, our office I believe with pretrial was trying to confirm whether that was a robbery conviction, because as on his GCIC, it does appear that it was amended to a disorderly conduct. In addition to, Your Honor, the defendant does have a arrest for aggravated assault and reckless conduct from Atlanta in 2019. He has a criminal trespass and civil battery out of Cobb from 2015, obstruction out of Butts from 2020. He has FTA'd out of Fulton County in 2020. He has a fleeing and eluding and a simple assault, family violence, and a battery family violence for 2020. And again, that Brookhaven robbery that appears to be amended to disorderly conduct from 2018 with a disposition in 2019, as well as the same charges of criminal trespass and disorderly conduct from Atlanta in 2017, Your Honor. Because this case does involve a firearm, the state is going to go with the 12 months to serve, Your Honor, as that is the standard for our office. Nothing further.
Should I proceed, Judge?
Give me one moment. I'm looking at this file.
Okay.
All right, you can proceed, Mr. Finley.
Yes, Judge. Mr. Bullock is a man, he's a former, he was in the Army. He does battle serious health issues. He has, it's called degenerative spinal disorder or disease, where he has bone spurs in his cervical spine. He does have one daughter that's 3 years old who lives in Macon that obviously he has not seen in a long time. Finances are a big issue for Mr. Bullock, and I have previously tried to argue bond for Mr. Bullock, and he just has no chance at paying this bond. So he's in there, and that is why we are addressing jail time, Judge. Mr. Bullock has now been confined for 124 days at the Fulton County Jail, and actually, as we know, the Georgia State House recently passed a bill allowing people to carry a gun without a license. That being said, I do understand the allegations and the seriousness of these allegations, and I did review that with Mr. Bullock. That being said, he's been sitting within the four walls of his cell for 124 days now. If he takes this, after the 2-for-1, he'd serve 56 more days. So obviously 124, I'm not sure what 56 additional days are going to accomplish that 124 days sitting in a cell did not already accomplish. And that's why I really think after speaking with Mr. Bullock, he's someone that will, if given an opportunity, will get out, try to rebuild his life, spend time with his daughter. And that's why we're asking for the time served deal, Judge. And I did review obviously all the different avenues and options, and he was very adamant that he wanted me to argue for the jail time for the non-negotiated.
All right, so just so you know, Mr. Finley, I've looked through this file and I've read what some of the other judges have said with regard to Mr. Bullock. I've reviewed his background. I've reviewed what he's done after receiving this charge, and it will be my sense that I'll be following the recommendation of the solicitor, given the totality of his history in regards, and especially his history after receiving this charge. So if that's something that he wants to accept, then I'm happy to proceed this morning.
Understood, Judge. Mr. Bullock, if I could, I guess since he would be in regardless, I would like to review this with him and my supervisor as well, just to make sure this is what's best.
Do you want to put this off till next Tuesday?
Yes, Your Honor. Yeah, if we could do that, I would feel more comfortable doing that.
That's fine. We will reset this for the 12th. All right. We'll see you back next week, Mr. Bullock.
Can I speak to Mr. Freeman real quick?
He's gonna speak with you after court, Mr. Bullock.
Yeah, I'm just on the phone.
He wants to talk to him on the phone, Judge.
Okay.
All right. I can give a call.
Mr. Scroggins? Position 22, Scroggins.
Good morning, Mr. Scroggins. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have the case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you.
And Judge, I apologize. Didn't mean to cut you off. I do have an update. It will be a bond hearing this morning. It is no longer a negotiated plea.
Okay. Does he need to be arraigned this morning?
Yes, Your Honor.
All right. Mr. Scroggins, you've been charged in case 22, thank you, 22 CR 001660G with driving under the influence of alcohol less safe and driving under the influence of drugs less safe. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. Scroggins? Guilty or not guilty?
Not guilty.
We will record you're pleading not guilty. Is that right, Mr. Scroggins?
Yes.
You record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of when that next hearing will be. Let's see. Is there a history, Mr. Howard?
Yeah, 10 total. Last arrest was 2019, domestic assault and battery out of Oklahoma. All of his history come out of Oklahoma. 2015 DUI NOLO. Everything else is either early 2000s or 1990 that I saw.
All right. Ms. Webb?
Yes, Your Honor. This incident arose on March the 21st, 2022, around the 4265 Shirley Drive, Atlanta, Georgia address, when Mr. Scroggins was pulled over by investigator Moncrief. Your Honor, the officer did witness the defendant traveling in a dark colored GMC at a high rate of speed, approximately 10 to 15 miles over the posted speed limit. The officer did pull the defendant over, Your Honor, and upon making contact with the defendant, he did have a smell of alcohol emitting from his person and from the vehicle, Your Honor. And upon further investigation, the officer did conduct a field sobriety test based upon the defendant's slow speech. The defendant's glossy eyes and his pupils were dilated, and the strong alcoholic odor that was coming from his breath at the time, Your Honor. The officer did note that the defendant was not wearing any contacts or anything that could lead to that glossiness, Your Honor, and that while doing the field testing, that the defendant dozed off in a semi-sleep or unconsciousness state for about 1 to 2 seconds and almost nearly fell over, Your Honor. For those reasons, the officer did charge the defendant with driving under the influence of alcohol, under the reasonable belief that he was operating that GMC vehicle, Your Honor, under the influence. As we've heard from pretrial, we do believe that there is a risk of reoffending, Your Honor, as the defendant does have that previous DUI. from, I believe it's 2015, Your Honor. And considering that DUI always proposes a threat to the community, especially when you're operating a vehicle over the speed limit, Your Honor. We are grateful that Mr. Scroggins himself was not injured in that he did not injure anyone else. But anytime anyone operates a vehicle under while inebriated, Your Honor, it always poses a threat to the community and to the defendant themselves. And the state is concerned for those matters. And we request that the court honors that $2,000 surety bond that is imposed on each count for those charges with the conditions of no driving and no alcohol, drugs, or weapons while out on bond, Your Honor.
Ms. Helen?
Yes, Your Honor. Could pretrial read his history for me, please?
Ten total. Last arrest was 2019 domestic assault and battery. He has a 2015 DUI where he pled no.
Thank you. I missed that the first time. I just wanted to make sure when I spoke to Mr. Scroggins, he informed me he believed that 2015 was expunged through an attorney that he had hired. However, here we're learning that it was just a NOLO entry there. Judge, I wanted to have his history read because that last charge of the DUI is in 2015. We are having a bond hearing today because for Mr. Scroggins, that particular moment, we are taking this to trial because he is stating that in this particular case, he was definitely not under the influence of any drugs and definitely not under the influence of any alcohol. And so when we were speaking from this case, we are asking that because he has no family in the local area, his son lives in Fort Benning and has so for 3 years, but no one in the local area. So he has no one to bond him out, no one to sign his bond to be able to allow him to leave the Fulton County Jail. So Judge, we are asking for a signature bond for Mr. Scroggins. If it's a split bond, he has no way. It's effectively no bond for him. He's 53 years old. And when this incident did happen, again, he was living on Fort Benning. He has been working as a union worker for the last several months. Prior to that, he was working for the University of Georgia as another union worker position. Again, he has been in the Muskogee County for the last 3 years as a Georgia resident. Yes, he is from Oklahoma. Again, however, he has been in the state of Georgia for the last 3 years. So just going by the Ayala factors, Judge, I do believe he will come to all of his court dates. I do have an updated address, 5520 32nd Armour Way, Fort Benning, Georgia, 31905. He will receive all his court appearances. I do not believe he will reoffend because I think he understands the seriousness of these charges facing him right now, Judge. So we are asking for a signature bond. He has 3 children total. The one son living in Fort Benning, 2 other children that are 8 and 12 years old, Judge. So yes, we are asking for a signature bond for Mr. Scroggins today. Again, because if it's a split bond, he will not be able to leave the Fulton County Jail.
Do we know why the previous bond that was set says no driving without a valid license? I mean, I would assume that he has a valid license if he wasn't charged with driving without a valid license, right?
Your Honor, I've realized that some judges will say you can drive so long as you have a valid license. So I've seen some of that language on previous bond orders. So I would say, I believe the no driving condition is, and what based on, I see what you're saying, that was entered on March the 23rd. I read it as he can drive so long as he can have a valid driver's license, but the state did request at the time no driving. But that order also includes a defensive driving course as well, Your Honor.
Right. Okay, so Ms. Helen, I'm going to convert the good bonds to signature bonds through the jail. I'm also going to convert the no driving without a valid license into a no driving, except for to and from work. If he has a job, then he can go to and from his job. And no drugs or alcohol while out on bond. So if you'll make that modification for the court. All right, good luck to you, Mr. Scroggins.
Mr. Scroggins, did you understood what happened? Your bond has been modified to a signature. The conditions are no driving with any drugs or alcohol, but also if you must drive, it's to and from work only.
Yes, ma'am. Yes, ma'am.
Only if you have a valid license. If you don't have a valid license, then you can't drive at all. So,
Correct.
You have valid license, yes.
okay. All right. Good luck to you, sir.
Thank you, Judge.
Judge, what's that total?
Mr. Walker,
4,000, 2,000 each SOB through the jail. What position?
this is an add-on, position 4.
Let's see. I know that we're right up on our 11 o'clock calendar. Who's representing Mr. McCoy?
I am, Judge.
You might want to speak with him.
Sure.
All right. Thank you. You understand what I'm saying?
Yes, Your Honor.
Okay, thank you. And this is Mr. Walker?
Yes, it is.
Oh, yes, Mr. Walker? Okay.
Yes, sir.
Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? You swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. You can put your hands down. Mr. Finley, what are we doing with Mr. Walker today?
Yes, Your Honor. This is going to be a negotiated plea.
Ms. Duncan?
Yes, Your Honor, for the record, for the charge of simple battery, family violence, and simple battery, family violence, the state recommends 12 months to serve, 198 days, credit for time served, 99 days, with the balance probated, a family violence intervention program, 40 hours of community service, a stay away from 158 Fairburn Road, Southwest Atlanta, no further contact with Donna Green, and Green is spelled Greene, and minor child C. Green.
All right. The calendar says to serve, I don't know if it makes a difference. I just want to make sure the paperwork is correct. To serve 180 days, and you said 198 days.
Well, 1 second, let me verify, because.
Yeah, on the offer that we got, it says 180 days.
My apologies, hold on 1 second, let me just check. That might be a scrivener's error. One second. Apologies, beg the court's indulgence for just a moment.
I understand you're looking for it.
Just 1 second. Okay, 1 second. Here we go. Here we go. Yes, my apologies. The state's recommendation in this case, for the record, for 2 charges of simple battery, family violence, for the defendant Marcus Walker, case 21 CR 0080018, is 12 months to serve, 180 days, credit for time served, 90 days, with the balance probated, family violence intervention program, 40 hours of community service, a stay away from 158 Fairburn Road, Southwest Atlanta, no further contact with Donna, common spelling Donna, Green, spelled Greene, and minor child C. Green.
Mr. Finley?
Yes, Your Honor. That is our understanding of the plea offer. And we're just asking that once he completes the 40 hours community service and the intervention course, if his probation could be terminated or become not reporting judge.
I'm not willing to terminate it. I will allow it to go to non-reporting.
Understood. Thank you.
All right. Mr. Walker, it's my understanding that you wish to plead guilty to 2 counts of simple battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Mr. Walker. I'm going to waive your probation fees while you're on probation, and once you complete the terms of the probation, it will go to a non-reporting status, okay?
Yes, sir. Thank you.
All right. Good luck to you, sir.
Thank you.
Take me too.
Harris. Position 11, Harris.
Good morning, Mr. Harris. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Harris? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Harris. Ms. Duncan?
Yes, Your Honor, for the record, that for the charge of criminal trespass, the state is recommending 60, credit for time served 61 days with the balance suspended and a stay away from the BP station located at 3040 Lakewood Avenue.
Mr. Fairman?
Yes, Your Honor. That is our understanding of the recommendation, of which we do agree, and additionally stipulate to the factual basis venue and ID.
Thank you. Mr. Harris, it's my understanding you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Harris. Good luck to you, sir.
Position 29, Winston.
Good morning, Your Honor.
Good morning. This is also going to be a negotiated plea, is that correct?
Right, Judge.
Mr. Winston, I'm Judge Eric Mara. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Mr. Winston?
Yes, sir.
And so you agree to have this heard over video today?
Yes, sir.
Okay. Can you raise your right hand for me, Mr. Winston? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you. Ms. Webb?
Yes, Your Honor. In this case, the state is recommending 12 months to serve 71 days, credit for time served 71 days, balance probated with a family violence intervention course, a stay away from 1275 Highway 54, Fayetteville Road, or Fayetteville, Georgia, excuse me, suite number 201. No further contact with Miss Lanita Winston. That's Lanita, Lanita, Winston, Winston, 20 hours of community service. And just to clarify, Your Honor, I believe Highway 54 also goes by Fayetteville. There's a Fayetteville Road as well, Your Honor. Excuse me.
Yes, Your Honor, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID. We would just ask that once his conditions are completed, it could be non-reporting, and that I do believe you'll waive his probation fees.
Mr. Winston, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir. If I may speak, they took my driver's license and because I had a failure to appear. But that's because everyone in my family died. My mom, my dad, sisters, brothers. I'm the last one. So I was going through something mental.
Okay.
I mean, like 5 funerals.
All right. I'm sorry for your loss, Mr. Winston. But you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
Okay, I'm gonna accept your guilty plea as negotiated, Mr. Winston. I'm also gonna waive your probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, it'll go to a non-reporting status, okay?
Your Honor, they took my license too because of the non-reporting. I'd like to have my driver's privileges back, please.
Okay, you'll have to speak with Ms. Helen or someone else regarding the driving privileges, okay?
Okay.
All right. Good luck to you, sir.
Thank you so much. God bless.
You also.
Thank you, Judge.
Mr. Gresham, position 8, 9, and 10.
Good morning.
Hi, good morning, Mr. Gresham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Gresham? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you. Let's see, Ms. Duncan.
Yes, Your Honor. For the record, on position 8, that's 19 CR 004901Y. It is a negotiated plea for the charges of simple assault, criminal trespass, and obstruction of a law enforcement officer. The recommendation is credit for time served 102 days, balance suspended, and a stay away from the incident location. For position.
Okay, let me see. What's the incident location?
One moment. They're all at 3435 Roosevelt Highway. But this one specifically is the Metro PCS located at 3435 Roosevelt Highway.
Okay, thank you.
For the next charge, on position 9, for terroristic threats and criminal trespass, the state is recommending credit for time served, 217 days, balance suspended with a stay away from Sasha Sweets at that 3435 Roosevelt Highway. We were able to contact the victim. She would also like to add a stay away from her personal confidential address, just in case. For position 10, criminal trespass, the state's recommendation is credit for time served 102 days, balance suspended, stay away from 3435 Roosevelt Highway, which is the Wayfield grocery store. Would Your Honor like for me to send the confidential address from position 9 in the chat?
I guess along with the person's name.
Yes.
Because it's Sasha Sweets. Is that a location?
Yes, that's her retail location in the plaza at 3435 Roosevelt Highway.
So is her name Her name's not Sasha Sweets, though.
No, that's not her name. That's the name of the business.
Okay, but she wants to stay away from her personal self and from her personal address.
Yes, because she's very concerned about the defendant's behavior.
I understand, but I'm gonna have to know what the name is of that person that he's to stay away from. Right?
Okay, so her name is, I apologize, I didn't understand what you were asking. What is it? Her name is Shalanda Hill. SHALANDA, Hill, common spelling.
All right, thank you, Ms. Duncan. Mr. Finley?
Yes, Your Honor. We just heard the recommendations, of which we do agree to the state's recommendation, and that it would be time served and balance suspended for each of these cases. And additionally, we stipulate to the factual basis, venue and ID, Judge.
Mr. Gresham, it's my understanding in case 19 CR 004901Y, you'd like to plead guilty to the charges of simple assault, criminal trespass, and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
In case 20 CR 004380Y, you'd like to plead guilty to terroristic threats and criminal trespass. Is that correct?
Yes, sir.
That was a yes? I'm sorry.
Yes, sir.
Yes?
Yes, sir. Yes,
Okay,
sir.
thank you. In case 21 CR 002391Y, you'd like to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the pleas as negotiated. Mr. Gresham, you know you can't be going back to this 3435 Roosevelt Highway. You understand that?
Yeah.
All right, good luck to you, sir.
Could I get them to verify that where they had me locked up at, sir? They had me locked up at 3399 3395 Mr. Roosevelt Highway. That's what they put on the ticket.
Mr. Finley, I'm not understanding what he's saying.
Sorry, I'm not understanding either. Could you repeat that, sir? I didn't understand.
I was just trying to get them to verify the address because I had the paper where they locked me up. And they locked me up at 3395 Roosevelt Highway. And that's what I was telling them, ain't no such address. You know, that's what they got on here, where they locked me up at.
Okay, I think Mr. Gresham, I think the address is 3435 Roosevelt Highway, okay? And that contains the Sasha Sweets location and a Wayfield grocery store. You know where that is?
Yes, but that one where I was when they locked me up though. I was at 3489 Roosevelt Highway. And they brought me back down to 3435 Roosevelt Highway.
All right, well, Mr. Gresham, if I was you, I'd stay away from all of them.
I am.
Okay. All right, good luck to you, Mr. Gresham.
All right.
I said back to the great door. Straight ahead to the great door.
We're completed here in Courtroom Two, Judge.
All right, thank you. See you this
We'll see
afternoon.
you at 2:00 for misdemeanor.
Okay, good, I appreciate it.
Oh, Mr. Gresham wants to know his.
Say it again. Okay. Let's see, before we do the bench warrant calendar, let's go over the,
I'm sorry, Judge. He wants to know the final plea, Mr. Gresham.
he wants to know what?
What's the final plea?
It's time served.
Oh, okay. That's what I need to know.
Okay?
Thank you, sir.
You're welcome.
All right.
Thank you, Judge.
All right, y'all have a good rest of the afternoon, rest of the morning.
Thank you, you too. See you at 2 o'clock.
Okay, very good. All right, so when Ms. Middlebrooks is ready, we'll go over the all-purpose calendar, and then we'll do the bench warrant.
Position number 1 is a plea. Position number 2 is a
Is everybody on that wants to be on?
I'm listening.
Yes, Judge.
Okay, all
I'm here,
right.
Your Honor.
All right, so everybody's here. Thank you. Go ahead.
Position number 1 is a plea. Position number 2 is a plea. Position number 3 has been reset SAP April 12th. Position 4 is a plea. Position 5 is a plea. Position 6 reset SAP April. I'm assuming this is the 12th. I have 11.
Yeah, I think it's supposed to be the 12th.
Okay. Reset SAP April 12th. Position 7 is a plea. Position 8, 9, and 10 were all pleas. Position 11 was a plea. Position 12 was a plea. Positions 13 and 14 were both pleas. Position 15 was a plea. Position 16 was a $7,000 sign-on bond through the jail bond modification, reset further notice. Position 17 was released. Position 18 was a plea. Position 19 was a plea. Position 20 was a plea. Position 21 took a plea on March 31st. Position 22 was arraigned, not guilty plea. There's a bond modification for $4,000 sign-on bond through the jail. Positions 23, 24, 25, 26 have all been reset to the April 12th SAP. Position 27 was a plea. Position 28 was a plea. Position 29 was a plea. Position 30 was released. On the add-on calendar, position 1 has been reset to the SAP April 12th. Position 2 received a bond modification or $5,000 sign-on bond through the jail. Position 3 reset SAP April 12th. Position 4 was a plea.
Okay, any questions or concerns regarding this morning's calendar? Okay, if not, let's move on to the DV bench warrants. I know that we reset Mr. McCoy from last week, although I don't remember why. What were we doing with Mr. McCoy?
Mr. McCoy, today we're ready on Mr. McCoy. I've spoken to him and we're ready.
Okay, and let's get him to activate his camera now.
Mr. McCoy, if you can hear us, go ahead and turn your camera on for us. Thank you.
All right, and just so that, is Mr. Ronnie Campbell on the line?
He's right there, Judge.
And who's representing Mr. Campbell?
I am, Judge.
Have you spoken with him?
Yes, I have, Judge.
And what about Pernell Robinson? Is Mr.
He's there, Judge, as well.
Okay, and are you representing him also?
Yes, Judge.
Okay, very good, thank you. What's going on with Mr. McCoy?
Today, Judge, with Mr. McCoy, we're asking you to set aside this bench warrant. Currently, he's a disabled veteran, has been disabled for the last, has been disabled for the last several years, was honorably discharged from the Army after serving 4 years. Currently, the FTA that was recorded was January 19th of this year with Judge Susan Edeline for a plea and arraignment, as well as, I believe, not another court date, but I believe the arrest warrant was issued January 24th. And there's a bond forfeiture scheduled June 10th. And so when I spoke to Mr. McCoy, he had no notice of either of these dates. I do have an up-to-date address for him of 961 Lena Street Southwest, Atlanta, Georgia, 30314, Unit B, as well as an email address and a working phone number. Yes, Your Honor, when I spoke to him, he wanted to come to court, but he didn't know that those court dates had been scheduled because they had an old address of 1357, which he does not live. Again, currently he lives at the 961 Lena Street. So Judge, we are asking for this bench warrant to be set aside. I do believe he will appear for all of his court dates because I've spoken to him and he understands how the seriousness behind these charges.
Duncan?
Yes, Your Honor, the state is vehemently opposed to the setting aside of this particular bench warrant. This case started out as a felony with the case number 21 CP 199424. And the victim in that case was a Miss Marticia Wheeler. At that time, the defendant received a $10,000 surety bond with a specific condition to stay away from this defendant. And in fact, our office has reached out to this victim and she stated to our prosecutors that she is currently living at that same address with the defendant in violation of the bond order set by the court. That 961 Lena Street address, given the violent nature of the offenses that are alleged in the warrant for those cases, we are concerned about intimidation of this witness, risk of reoffending, as well as the fact that this defendant does have previous FTAs. So we are concerned with the flight risk because he did not appear for plea and arraignment. There's probation violation from June 2017. There is another FTA on the record for theft by shoplifting, at least an arrest in 2017 of September, as well as another FTA for felony theft by shoplifting from December 2018, and an FTA arrest from September 2020 out of Coweta County for OC unlawful acts in violation of a penal institution, as well as this defendant has an extensive history going back to 1992. He has 45 cycles with more than 10 convictions. The last I saw on the record was 2020, a guilty conviction for riot in a penal institution. Your Honor, we're concerned about the safety and health of this victim. Given the facts, there were weapons involved in this altercation. The defendant had to pull a knife to get the defendant off of her. When police responded to that location, the defendant was spreading profusely, and the only thing that started the altercation was the victim asked him why he was sweating because she was concerned about his history of drug abuse. And then one thing led to another, and they began to fight. He grabbed her around the throat, and in fact, because he said that he wanted her out of the house, he charged at her and began yelling. And when she attempted to call 911, he grabbed the phone out of her hand. Officers observed bruising on the side of her face and redness in her throat, which were documented at that time. The defendant does suffer from a medical condition called lupus. And we're just concerned about her health and safety at this time, because as we stated, this defendant is in clear violation of the court's order to have no contact with this defendant. And he's updated the address recently as the current address that this victim lives at.
Do you have the previous bond in front of you, Ms. Duncan?
Yes, I do, Your Honor.
Okay, and who set that bond?
This bond order, it's signed by Ashley Drake.
Okay, and what are the conditions?
The conditions are a $10,000 good bond. You'll be notified of your next court date. You have no contact directly, indirectly with the victim's family, professional, personal, or close associates by phone, mail, email, or through third party, including at victim's workplace, church, home, and daycare. If you encounter the victim, you must leave immediately and must not come within 200 yards of the victim. The victim's name in this case was Matika Wheeler, Maticawheeler, who is the victim in this case. Other conditions were a stay away from the 1350 Mason Turner Road address. However, the victim indicated that they have since moved since this incident, and there is a change of address form for the bond set aside order, and the new address that the defendant wrote in on that form is that 961 as the public defense has stated, and that is confirmed to be the same address as the victim in this case by our prosecutors, Your Honor.
Okay. So that's a problem, Ms. Helen.
There may be another location for Mr. McCoy to relocate to.
Well, well, that's not the problem. The problem is that he's in violation of that previous bond where he was specifically told that he was to have no contact. You know, so that combined with the fact that he is just flagrantly letting the court know that, you know, he's in violation. I mean, you know, he's the one that gave us the address. So, all right.
Could I have a moment to speak to Mr. McCoy, please? Just a moment to give him a call real quickly.
Let him know what I'm about to do.
Understood.
All right. We'll be in recess until you get back.
Could you put us in a breakout room? Is it possible that me and Mr. McCoy can just be put in a separate breakout room, please?
Yeah, I can do that. It's just, yeah, I can do that. We just gotta know how to set it and come in and out. So that's all we think about it.
Thank you. State court, Mr. McCoy is saying that his screen has been disabled by the state court. If you could enable his screen.
I'll kick them back into the main session. Give me a second.
Thank you.
You should be in the session now. There you go.
Thank you. And if we could just go back to the breakout room, again, they were having issues turning their video on.
Okay, so you want to go back in the breakout room again?
Yes.
Okay.
Ms. Lewis,
Yes, sir.
would you let Ms. Helen know that we need to move court forward, please?
I sure will.
Thank you.
She got 7 to 10 days.
Judge Morrow, I no longer have anything for the court. I'm gonna sign off. Just want to let you know. I've been doing paperwork for you though, so just haven't been.
Okay.
I know, right?
We'll
No,
see you
I've
next time.
been doing paperwork. I just want to say that. Have a good day.
All right, you too.
All right, bye.
Yes.
Judge, we're ready on Mr. McCoy.
Okay, go ahead.
So when I spoke to Mr. McCoy, there was a key breakdown. I understand where you're going, Your Honor, and I can hear from the history why. Mr. McCoy and Ms. Wielder were under the impression Mr. McCoy was being brought to the hospital after their argument. I understand from their argument, he was then brought to the jail. There was no hospital visit. He was not arrested at the hospital. He was taken directly to jail. At his first appearance, that judge notified him that, no, this is no longer being treated as an aggravated assault by strangulation. You're being transferred to misdemeanor court, and did not tell him the bond conditions of stay away from Martisha Wielder. In fact, she was there. So that was a key missing point. He was under, as well as her, which is why I believe she told the ASG, yes, I'm in contact with this individual. And yes, I'm currently living with this individual, not under the impression that there is a current no contact order. So Judge, I would be asking for the bench warrant to set aside, and also the opportunity to change that no contact with Ms. Wielder to no violent contact.
I mean, you couldn't have gotten more specific in that. That's much more specific than the warrants we get that we have, or the orders that we have. I mean, this order specifically stated what he was not supposed to do.
Understood. When he said he had no idea of the conditions of that order, that on that court date, that judge told him of the transfer to misdemeanor court and not the conditions. Because he and Ms. Wielder would have both said, no, we need no violent contact, because they currently are depending on each other.
Okay. Ms. Duncan?
Your Honor, given the facts and circumstances as stated by the state in this situation, the current living situation is entirely improper and in violation of the state's order. At the time, he recently updated the address, and we would just stand on the fact that we would object to the setting aside, and we would ask that he be remanded to custody. And he didn't update his address prior to the FTA. It was recently updated, and that's the address where the victim also lives. And it's if I may, one more, it's his responsibility to clarify his bond conditions as well with the court, including his picture.
I'm going to give him 1 week, Ms. Helen. I'm going to give him 1 week to find himself other living arrangements. I want to bring him back in, and that's not saying that I'm gonna set the bench warrant aside. I need to have more to look at, and I need to have, this is more complicated, so I'm going to bring him back next week, but he's going to have to find himself someplace else to live, and he's going to have to do that within the week.
I will speak directly to Mr. McCoy and make sure he understands that.
Okay, and then I'll address this again, again next week.
I understand, Judge.
All right, so you tell him that in a minute. Let's go on to the others that are waiting. What are we doing with Mr. Robinson? You're on mute, Miss Helen.
Judge, we are asking for that bond bench warrant to be set aside.
Yes, sir. Good morning, Mr. Robinson. Hold on a moment for me. And why are you asking that the bench warrant be set aside?
Yes, Judge. When I spoke to Mr. Purnell, he was not aware of those court dates for those failing to appear. We do have an up-to-date address.
What's the updated address?
Of a 3035 Duke Drive, Fairborn, Georgia, 30213. We also have an email address as well as an up-to-date number of a 706-639-7050. When I also spoke to Mr. Robinson, he actually has 4 children that he's a primary caregiver of. He has his CDL license and has had it for the last 21 years because he is driving trucks. I think he actually has his own company within the truck driving business. And so, Judge, with this father, we want him to be able to go back to work, continue to work. So we are asking for this bench warrant to be set aside. That failure to appear was for May 10th, 2021, plea and arraignment with Judge Patsy Porter. And I do believe, I didn't see what type of hearing it was, but there was an August 31st, 2021 court date with Judge Patsy Porter that was notified as an FTA, but either he had no notice of, Judge. And I do believe they had an old address of a 900 Meadow Glen Parkway, apartment 218, Fairborn, Georgia, 30218 or 30213.
Ms. Duncan?
Yes, Your Honor. In this case, it is the state will first object to the bench warrant being set aside, and we would ask that the defendant be remanded into custody. As the public defender has stated, the defendant did in fact change his address to 3035 Duke Drive, but we wanted to bring it to the court's attention that that is the same address on the police report that was taken at the time of this incident on May 6, 2018. So it's the same address from the police report. So we are concerned as to how did his address go from where Ms. Helen stated it to the address of the incident. And given the nature and facts surrounding this case, when officers arrived on scene, Your Honor, they witnessed the defendant having the victim in this case in a chokehold. The victim sustained.
Was there a stay away, Ms. Duncan? I'm sorry, I don't mean to cut you off.
This defendant was released on a copy of the department for the charges and transported to Grady.
That's not responsive to my question. My question was, is there a stay away from the alleged victim?
We don't have the current bond order, Your Honor. One moment. One second, Your Honor. From our understanding, Your Honor, we don't currently have access to that information. However, he was brought in for the failure to appear, as Ms. Helen has stated. If you give me 1 second, I'm gonna check another place. Beg the court's indulgence. Currently, Your Honor, my apologies. We don't have the information in regards to the bench warrant. We're just, the information available to us is that this defendant failed to appear twice. And given the violent nature and circumstances, we're concerned about the safety of this victim. And we noted that this was the actual incident address for the police report that was taken at the time of the incident.
Okay, so this is what I'm gonna do in this regard. Mr. Robinson, it's your obligation to inform the court when you move, all right? So you're gonna get one additional opportunity to show up, okay? So I'm gonna set aside this bench warrant this time. If this happens again, then the bench warrant will not be set aside an additional time. Also, Ms. Helen.
Can I, excuse me, Judge? Can you hear me?
Yes, I can hear you, Mr. Robinson, but I have to say you have a right to remain silent. Anything you say can be used against you. Okay, so you've got Ms. Helen here speaking on your behalf. A lot of times people think that something that they say is going to benefit them when in actuality it doesn't. All right, so with that said, is there something that you want to tell the court?
Well, the address that they had on file, where they said they were sending the correspondence to, I never lived there. We built our house from the ground up 6 years ago in Fairburn.
Okay. All right, so I'm giving you one opportunity. So if you get another notice and you don't show up for court, and they put a bench warrant out for you, then it won't be set aside a second time, okay?
Yes, sir.
Your Honor, the state would just like to add that the defendant has admitted to having the same address for 6 years. So if there was no indication of court received, we don't know how it would have gotten lost in the mail if he had the same address.
Okay, I've made my ruling. Have a good day, Mr. Robinson.
Thank you.
Ronnie Campbell.
I've been trying to get Mr. Campbell to start his camera. I've been trying to get Mr. Campbell to connect auto. I don't think he can hear anything.
All right, so we're gonna reset Mr. Campbell till next Tuesday.
He has not responded to none of my chats.
Okay, thank you.
Understood, Judge.
So you speak with Mr. McCoy. We'll see him next Tuesday, and we'll hopefully see Mr. Campbell next Tuesday.
Understood.
All right, anything further?
No, Judge.
All right, I'll see you all next time.
Thank you.